Well, I instructed them to produce all 3 sets of question paper and also the resolution. May I hand over?
No, Mr. Dhar, if
Yes.
resolution is not part of the record, how can I consider now?
Part of
At the
the
midst of hearing, no document can be allowed to be passed. No,
well,
no document can be allowed to be placed.
all I'm saying is that there was no resolution. That has never been an allegation.
That was the question of the court.
Yes. But the in the
Very
writ-
good.
well, kindly consider that in a writ proceedings, Lordship is seeing in the judicial review. Now, in any selection process of
No,
that,
Mr. Dhar, I understand your contention, but if I allow the parties to file documents
no file
in
document.
this fashion, hearing will never start.
No, may I say that?
If I allow you to place this document, they will take. I'll give me the copy. I will use the exception to that. They may take this point that this is an afterthought document. So this document
No,
cannot be
may
placed
I-
at this stage, sir.
well, these are the first,
Whatever is there is there. That is there. That is there.
but there is on affidavit.
No,
we
sir,
say-
I cannot allow you to file this.
may I say this, my lord? I can understand what Lordship is.
Otherwise, it will be an endless litigation.
No, Lordship is not allowing. May I say this? Kindly hear me what I'm trying to say. There is a difference between that on my affidavit. I have never disclosed.
No, sir. You ought to have placed all your cards before this court to show your bona fide.
Well, including
At this juncture, I cannot allow you to file.
including question papers.
Sir, that is up to you. I don't say that it is required for you or what. As per the prudence of your commission,
Correct.
your client, they have placed all the cards
Right.
to show their bona fide stand.
Correct.
The lease will be decided on the desk.
But my lord, in a writ proceedings, my lord, there are thousands and thousands of examples when court asks, I want to see the record, and court looks at the record also.
Very good, sir. I shall see only the question papers, but not the resolution.
May I hand over these 3 sets of question papers?
There I can see.
Well, these are the only originals. Even I don't have anything. Now, the red colors, these are comprised of 3 sessions, all are preliminary. The red ones.
Red ones are?
Red ones are, Lordship will find there are 3 categories are there. Session 1, Session 2, Session 3. There is an indications, Mallet, on the front page. If I can get one document, I can show where it is indicated. It is for Session 1. এই জায়গাটা একটু দেখে দিন। Well, this is, if I can show from this place, well, this is the heading is serial number 10 session and session 1. This is black. এই জায়গাটা একটু দেখে দিন এটা।
Yes.
Well, kindly see. Well, I have indicated that there is a session 1 which is marked black. There are some where the marking would be in session 2, and there are some marking would be session 3.
In the screening test.
Yes. Yes, that is the red document. And there are 2 other documents. Not 2, there are 3 other documents. One is 2 sets of written examination of 2011 and 2024 there is the impugned that written examinations, that question paper is also there. হ্যাঁ, 27th June. Lordship may also see the uh, level playing factor, that it should be of a class 8 standard. There was no such, like in 2024 there was it was deliberately made as if very easy. And now kindly see, my lord, the act. This is the Madrasa, the West Bengal Madrasa Service Commission Act 2008. The function is, well, there were some amendments.
Yes, sir.
Kindly take, my lord, section 8. Mental act, beta. Sorry. My lord, this is the function of the commission. My lord, why, my lord? May I just indicate, my lord, my purpose of placing my function? Because, my lord, in the last occasion, Lordship had indicated, with Lordship's experience of holding some selection uh, in the capacity of the honorable judge. Well, I was thinking that there, well, one thing, well, came into my mind. That's my purpose. Now, the ordinarily the functions of the honorable courts are the, well, the judicial functions. So the administrative functions are not the ordinary functions. Now, whereas so far as the Madrasa Service Commission is concerned, kindly see, my lord, 8 itself, because this has been set up for this purpose only. It is not that they are going to do something else other than what they usually do. Notwithstanding anything contained in any other law for the time being in force, or in any contract, custom, or usage to the contrary, it shall be the duty of the commission to select and recommend persons to be appointed to the vacant post of teachers in accordance with the provisions of this act and the rules made thereunder. Well, original section only contained with the teachers. Now there was an amendment in February 2003. There group D was in to the effect. Well, there, Lordship will see there the group D that was incorporated by section 2(1) within the definition of that non-teaching staff means the non-teaching staff other than the teachers and includes librarians, clerks, and other group D staff. মেন রিডটার নামটা কি? আব্দুল, হ্যাঁ? হুম।
বলেন বাবু, এই দুটোর মাপ
Now, my lord, the reason that I need to, my lord, satisfy your lordships that why the decision of the commission, my lord, the copy is there with me, why this was not annexed. Reason is, if lordship kindly take the writ petition itself, kindly come to page
পিটিশন
page
রাখুন আপনার কাছে।
10 to page 11 of the writ petition.
Yes.
Lordship will see that the writ petition is, for an example, kindly see paragraph number 2. The violation of the Honorable Single Judge's order, the violation of the Honorable Division Bench's order. Well, that seemed to be the entire domain of the writ petition. They have mentioned paragraph 2, this referring to single judge's order. Thereafter, paragraph 4, it's my lord, it is only the reference of the fact. Paragraph 6, again, my lord, this is, they have entirely copied the Honorable Single Judge's order. Paragraph 7, the copying of the Honorable Division Bench's order. Paragraph 8, again, the entire quote of the Honorable Division Bench order.
That is the core issue.
Yes, that's the core issue. All I'm, my lord, my effort before your lordship is this: if I don't have any case because of the Honorable Single Judge's order, Honorable Division Bench order, this is the perfect writ petition. But if that is not standing in the way, if the question is required to be decided that whether do I have a right to hold the written examination in a situation where I have detected the error, because I have, my lord, placed a judgment of the Honorable Supreme Court where the Honorable Supreme Court had categorically held if an error at any stage, possibly then I would have only two options. Once, my lord, as a selector, once I detect that there is an error, that, my lord, 3 red question papers I have given, once I see that through sets, that is session 1 and session 3, those were screened on the basis of the answer of session 2, which was their decision in the resolution, that also I have disclosed in my comprehensive affidavit. Independently, do I have any right at all to do anything? If I have a right to do anything, then what are those things? My only question to myself is, if I detect there is an error in a selection process, what do I do? Do I remain silent? Do I cancel it? Or I can correct it and move on? My respectful submission before your lordship is that once I have found that this error has happened in that screening, thereafter only two options are left to me. Only two options. For my mistake, no one can build his legal right to be more concrete legal right. My mistake has reduced the pool of competition. I completely agree with this point that in that circumstances, I had two options. Option number one, this is the kind of error. Because of this error, there would be a lot of consequential difficulties. So therefore, as a selector, I think we should start afresh with the same candidates, because rules of the game, I cannot now allow anyone, same candidates, so that everything can be fresh. And I don't think this would be unreasonable. This is one option. Other options, what I have done is, I found since my error was not in the main competition, error was only in elimination round, and I have the originals with me, I also allow this 73,000 who otherwise could have also participated under 1,43,000. So I chose that second round. And
in doing so, you have set the question papers in such a fashion
yes,
which is absolutely in level with the
yes,
question
of
papers
up 2008
of 2011,
yes, yes.
which would be evident from these two question papers.
My lord, may I, my lord, may I make a very humble prayer? If Lordship looks at the resolution, because my lord,
Resolution of which date, sir?
but this is the resolution dated 27th of June 2024. May I kindly have a look at thereafter reject it? একটু দিন। সবাই দেখতে পাচ্ছে এখানে? My lord, may I just place it? Lordship will find the chairman and all the members of the commission were there.
It may, if it is taken on record, it will be directed to me also.
My lord, usually the copy of the resolutions and others, unless anyone is entitled to, usually that is not given. My lord, may I just place this entirety? The chairman, West Bengal Madrasa Service Commission, and secretary, Minority Affairs and Madrasa Education Department, graced the chair, welcome all the members present, and initiated agenda-wise discussion. GH Obaidur Rahman, I secretary in the such and such department, and such joint secretary department were also invited to be present in the meeting. At the beginning, the Honorable Chairman explained the reasons for calling the meeting of the Commission. He placed the following issues for discussion, especially in respect of first SLSC 2010 for completion of the recruitment process of Group D staff in different madrasas. After thorough discussion, it was decided as follows. 1A. For compliance of the order dated 13/6/24 passed by the Honorable High Court in MAT number such and can such and such, the Commission will take all necessary action required to complete the recruitment process of first SLST Group D within 3 months from the date of the order. B. There were 272 tentative vacancies. Well, it was at the time of advertisement, and there was an indications. If any other, that would be included. Ultimately, it became 295. There were 272 tentative vacancies of first SLST of 2010, Group D. 1,92,241 number of applications were received by the Commission. 1,43,303 number of candidates participated in the preliminary screening test. And 26,445 number of candidates were found eligible for written test. 24,577 candidates appeared in the written test. Publication of the result of written test was kept pending due to the detection of error in evaluation of preliminary screening test, OMR sheets. All originals are still with us. The OMR sheets of 3 sessions of preliminary screening test were evaluated by the answer key of second session, and as a consequence 73,978 number of candidates who would have been eligible to appear in the written test did not get the chance to sit in the written test. Now it is decided that the commission will conduct written test of those 73,978 left out candidates and publish the result of written test within second week of August 2024. Since the recruitment process was initiated long back, 24,577 candidates who appeared at the written test and 73,978 candidates who did not get the chance to sit in the written test are to be requested by letter through speed post at their address as recorded in their application form to update their basic records including email ID, mobile number, WhatsApp number, Aadhaar number, present address for communications, and upload their Aadhaar card on the Commission's website by 16 July 24. Simultaneously, public notice regarding updation of data of the candidates and the written test will be issued thrice in newspaper for wide publicity. The standard of question paper of written test of Group D shall be same as that of held in 2011. It may be noted that the earlier question paper for written test was set separately for 2 sessions. The process of question paper setting and printing of Group D written examination, English and arithmetic shall be completed by 18 July 24. Written test is proposed to be held in last week of July or first week of August 2024. And personality test is proposed to be held in third week of August 24. Commission will notify all informations regarding examination on its website as well as on the website of the MA and ME department. Meeting with district authorities is to be fixed for conducting written test of 73,978 left out candidates of first SLST Group D. Commission will hold its meeting every week on Wednesday for discussion in connection with the Group D examination and other issues. Work order for Group D examination will be issued to the agency which worked for the Commission earlier in this connection. But next is, it's a separate issue. This was not connection with this. Second and third was separate. It was nothing to do with this. Well, this is section as I 9.
Yes, Mr. Thor.
But I was
এটা উকিলকে ফেরত দিন।
I was humbly praying before your lordship this part. Is it possible that in the selection process an error is detected? Well, my answer would be yes, it is possible. Then either my only course of action would be that I have to be silent on that, or other course, cancellation or rectification and go ahead. Cancellation and rectification go ahead, my lord. I believe that stands.
I understand your contention, Mr. Dhar. You have according to you have the commission had 2 options. First option is cancel the whole and take the examination afresh.
Yes.
And second option is to hold the unnecessarily left out candidates to hold a similar type of examination.
Yes. Yes.
That has been done.
Yes.
Mr. Dhar, the question now I am going to put is not, it may be not good for you. I mean, I need to say not for good for the commission.
I've understood.
I've seen the resolution.
Yes.
There is a watertight resolution. What I'm on, the commission is headed, the meeting was headed by an IS officer who is the
Yes.
chairperson.
Yes.
There is another IS who is also a member. There are 3 doctorates
Yes.
apart from the other members.
Yes.
What prevented them to approach the honorable division bench either in a review or in a single division in the event, why those prudent person have taken the risk for not approaching the High Court in the event this court, while disposing the instant writ petition,
Yes.
holds
Yes.
against you
Yes.
that the core issue before the division bench,
Yes.
while disposing the interlocutory application,
Yes.
something can 8 or can 10,
Yes.
those are the core issues
Yes.
for publication of the result without
Any delay.
without making endeavor to
Any
test any
fresh.
further examination, which according to which you are good as an arbiter.
Yes.
Why the does it not raise any question with regard
It
to
does.
the
It does. It does. It does.
just see
It
the
does.
conduct of the commission?
Does
it not raise any suspicion? I
Uh,
don't want to use this word, but
no, no. Lordship,
it
please
means
use.
it,
Ma'am,
because your contention is that it is an arbiter. But this court, the whole court holds that while not disposing the appeal, disposing the interlocutory application from time to time by the division bench for granting extension of time, and where this court holds that while granting the extension of time, the view expressed by the division bench for not allowing the commission to hold any further examination is not an obiter, but a core issue of the said application, not of the appeal itself. We understand. This resolution will go. Why the commissioner had taken such risk?
Well, there are two answers.
So
Well, there are.
I believe according to this court there are 3 options.
Yes.
First option, the bona fide option would be to approach the division bench. That has not been happened. Second option, to cancel the entire examination, detecting the notice for which the division bench can be moved, could be moved. And the third option, which you have opted.
Well, may I respond?
Does it not raise a suspicion?
It definitely
about
does.
the conduct of the commission?
May I give?
And if your commissions are chaired by so many prudent persons, unlike us,
No.
then what explanation you have got?
May I?
Why a candidate had to approach this court for issuing a mandamus for publication of a result?
True. May I give an answer? I have two answers. One answer which, leaving aside the legality, what is the practicality of the matter? That would be my first answer. Then I would give my legal answer also. What seemed to have happened is, well, sometimes in litigations I have observed that the party who wants some kind of relief is one party, and there is a party who is defending that. Sometimes respondent, because of their own, if I can use this word which is not usually used, they are messing up of the situation. For an example, there was every possibility to explain these situations as today this is happening before your lordship, before the honorable division bench in its entirety. There is an every possibility that things could have been different. But from a technical point of view, writ petition not being regarding error, division bench confined to the
that I do agree, sir. That I do
so
agree.
it was a risky.
It is within your ambit. It is within your ambit. According to you, that I understand.
It could have been. I also feel that it could have been, but it's a risky path where the legal acquaintanceship has to be such so that I have no other option but to approach before you has to be justified, as opposed to what was the fundamental issue. Lordship, may kindly look at this thing. Usually, before the Honorable Division Bench, the Honorable Division Bench would decide that it is upholding the whatever the Honorable Single Judge has directed, or setting aside of the same. Now, once it goes to upholding that, which is the case hearing, I, as a respondent, difficulty is that that line is a very risky and very slim to convince the Honorable Division Bench regarding what to do in case of error detection.
That error deduction does not come under the purview of sufficient cause within the meaning of Order 47 Rule 1.
Well, the answer could be no why. I'm saying this could be no why. Error detection was a subject matter in the application only for the purpose of time limit to comply of the single judge's order, which didn't have any component of the error detection.
Very good, sir. Very good. That you have argued, sir. Anyway.
Yes, that I have argued. So my submission before your Lord.
On the level playing field, you want to argue any further more?
Level playing field, yes, I have. Okay, let me come to level playing field. Right.
Because on the last occasion, you have referred
I was
clause 16.
Yes.
And to substantiate that you have maintained level playing field, you have produced the question papers.
Yes.
Very good. That I have understood, sir.
Well, if I can just add one line. For level playing field, my submission is this, that their fundamental attack of not level playing is based on separate question. Separate question was there in 2011 that I have placed. And 24, it is a separate question, but Lordship, your Lordship may also see, standard remains the same. For any moment, if Lordship reads the questions of 2011 and 2024 subsequently, Lordship will find it is not that
these questions papers are of the written test.
Of the written test, because I'm not saying anything on the preliminary part.
That has been assessed on the basis of that.
Yes, I said preliminary.
Those are at par almost. That I do agree with you, at least to this point.
I said that if it is, but I am not free from flaw person. I can't say that. But I was trying to say that should the writ petitioner get the benefit for that? Yes, I lost before the Honorable Division Bench to persuade, to convince that for error detections, I should be allowed to hold a separate examination. But the Honorable Division Bench was completely confined to whether I am ready to comply with the Honorable Single Judge's order or not. My problem is not the problem of the Honorable Division Bench. Now, my reason of showing 9, I am under the Act. So my functions, question is whether Honorable Division Bench have tied my hands in such situations. In my applications, it's my application seeking for more time, giving some time. My submission is it should be confined to timing, not my other thing. My other thing, if I'm otherwise illegal, should be set aside. And there I join only this. I have followed the level playing factor. Because of my mistake, nobody should try to gain anything. Yes, but there I also admit that I had another option of cancelling entirety. I had that option. But then I would be
Mr. Dhar, there is no requirement of repetition. I understand your
true,
point.
true. Well, there is a judgment. Aditi judgment was for level playing factor. Aditi judgment was referred by my learned friends.
Yes.
To that respect, I have 2009 5 SCC 694 because that was the judgment.
Page number?
This is 2009 5 SCC 694. 694. Paragraph 21. My reason of placing is Aditi judgment was an interim order of the Honorable Supreme Court. That matter is pending still. So therefore, interim order does not hold as a precedent for that. Yes, 21. Well, Mr. Mitro was indicating that Mr. Mitro already had that judgment. He was to place that.
No, I would just like that.
True,
You
true,
don't
true.
cite more.
Yes.
Kindly, the short two sentences. A precedent is a judicial decision containing a principle which forms an authoritative element termed as ratio decidendi. An interim order which does not finally and conclusively decide an issue cannot be a precedent. Therefore, usually, unless every aspect of the fact is identical, no one relies on an interim order saying this precedent requires to be followed in another matter. Yes, yes. For prejudice purpose, of course, that can be.
Yes.
Well, I made this submission. Just one judgment on that. This is 1992 4 SCC 54. This is, my lord, is very well known that singular includes General Clauses Act 13 says so, but there are judgments. It is
Paragraph number?
paragraph number 7. 1992 4 SCC 54, paragraph 7. It's my placitum B. Just 2 lines, if I can just say. Page 59.
Yes, sir.
Kindly see, my lord, page just little above placitum B, little right hand side from under General Clauses Act.
Yes.
Singular includes plural, act includes acts. The contention that there must be plurality of acts of misconduct to our dismissal of fastidious, the word act should include singular act as well. It is not the, well, I don't need to harp on this point because it is so well established. Now, my reason, it is related to.
So according to you, examination should be considered examinations.
Can to build up a castle on the singularity of the examinations may not be a good base for that castle to be built. They may have another point to say that there should have been one examinations, but my learned friends,
Very good. I understand.
and but I place this our parent act now, that function there. Now kindly come to, my lord, the rule itself.
এই একবার
Rule
রুলটা
16.
একটা দিন আর রুলটা দিন আমার ওই যে ওখানে রয়েছে না একটা রুলটা দুটো করে দিয়েছে
2010 rules.
অ্যাকশন রুল একটা ফালাতে
Act today I have just
জাজমেন্টে দিয়েছেন ওখানে একটা বার করুন আর এক্ষুনি যে রুলটা দিলেন ও রুলটা এখানে দিন আমার একবার
হ্যাঁ, correct.
আর রুলটা দিন একবার ইয়েস Yes.
Malad, here my submission is rule 16. The commission shall hold written test. This was the singularity. They said test means only one of all eligible candidates. And Lordship may kindly see the proviso, which was where this detection happened, provided that the commission may hold screening test before holding written test. In case the number of candidates applicants in any category of post is huge, particularly in case
For
of
the timing, we are not concerned because that is not disputed. Question is the commission shall hold written test. It should be read as test. As per
one.
the provisions of the General Provisions,
Yes, correct.
General Clause Act, vis-a-vis the reported decision of 1992.
Yes. Well, I'm trying to link this with there is a mandate on us, I being a creature of the statute. If I find is someone is eligible on the basis of the advertisement, 73,000 are all eligible. Once I find that they are eligible and they have been left out because of my mistake, do they lose the eligibility because of my mistake? So I am trying.
Mr. Dhar, I believe it would be your contention that the second mode which the commission had adopted are backed by Act, rules, and the Supreme Court judge.
Absolutely.
This much you want to say.
Yes.
I got your point.
Yes. But if I can just say one for my.
Yeah, I mean, including something.
No, Lordship has said exactly.
Just to cut short the matter.
Yes. No. I mean, Lordship has given me ample time. Even now, I am stopped. I will have no amount of unhappiness because I have got more than whatever usually we see in most of the courts. So I don't have any grievance on that. Just for sometimes, Mala, there is an emotional bonding with a case also for lawyers. Little bit of some kind of feeling happens when we spend time, read the documents. I think that is all about the professional aspects of, I think, anything. Some amount of love is there. So while falling in love with some cases, some briefs, sometimes we become little bit of unreasonable. and as guardian, sometimes your lordship somehow tolerate that part of us. So under that category, only one sentence that not only it is a situation that what do I do after this detection of error, but also it is a mandate if they are eligible. Rule 16.1. If I can just say this, 16.1 is a mandate on me not to disallow an eligible candidate. In a situations where I am aware that screening is not the competition, it's only elimination for my benefit, I won't be able to handle all. So I know 1,43,000 all are eligible, but still I don't want to give a chance to everyone. That's why I screen it. While doing that, I don't have a discretion to disallow if anyone is eligible. Once I have found my mistake, they are eligible, there is a mandate of 16.1. Well, deeply obliged. That. Well, the writ petitioners, excepting one writ petitioner, namely Joyanto Sarkar, he was found to be there in the eligible in the personality test, and he appeared in personality test all along. He is there. The all other writ petitioners, none of them they qualified in the written examination itself. So therefore, they are unsuccessful. Being unsuccessful, they filed a writ petition, and that's their point that they have said. I need
unsuccessful in where? in the
in the written examinations, according to them, well, we have held
two
written examinations.
Yes.
Lordship may take the first dates. I have there is a short 2-page.
No, the writ petitioner who are challenging your action, they were successful in 29/5/11 written examination.
No, none of them were successful to go ahead on the basis of the result of the written examinations. That's my point.
29/5/11 they were not successful.
29, may I say this? On 29/5/11, they could sit because of they were successful in the preliminary.
I understand, sir.
After that, the result when was published, they were not successful to go ahead with the personality test.
No, that is the outcome of the result of two examinations
Correct,
together.
Correct. Agreed.
Ultimately, the result, independent result of 29/5/2011 was never published.
Well, this was published. This was published.
No,
but
it was not separately published.
Not separately.
Not
but
separately
roll numbers are there, so all can be counted.
No, Lucas Standard is still there. Lucas
Yes.
Standard is still there. I understand. I got your point.
That's the reason I have not argued much on the.
Yes.
I'm sorry. Well, just a few numbers. Result of the written test when published, the total number 73,000 plus 26,000. Result was 3,233. They were selected for personality test. Now this 3,233, they were based on, as I said, 24,577 and 73,978. Now final vacancy was 297. My instruction is from 7, because these roll numbers are there, every details are there. From 73,000, maybe because of 10 years gap, there is a likelihood that, as they said, some of them even went for working, farming and everything, because it happens. It's not so stay away from the study and everything. There not many persons would qualify. So ultimately, in my final merit list, which was published on October this 24, total 295, approximately only 51%. They could be successful for all those 73,000. All from the rest, about 244, etc. They came from the pool of 2011 written examination. And that is from the because of the roll number, etc., that who sat and what examinations.
So those posts remain vacant still now.
No, all are vacant. Now 295 are vacant. Final merit list is there. This is also part of the record.
No, I understand. So if the court gives you to go ahead with,
yes,
then only 51 will be
only 51, because the entire
and the remaining vacancy will be
filled up all by the
in the subsequent.
Yes. Now writ petitioner's case would be that we could have come in that 51.
I understand, sir.
But this is
because of these persons inclusion, we have been eliminated.
Right. Because 73 have allowed, that has resulted.
Cut-off mark goes high.
Correct. That could be. Not necessarily mathematically it will happen.
Really, policy decision is that in an Vivabosi test or the we will call 1:5 or 1:3, something like that.
Yes.
So naturally, cut-off mark goes high.
True. And because assuming if this 51 go, of course some other 51 will come, and who will come, that will be according to whoever is marking. That is, well, neither here nor there. Well, there is one judgment that I just said, but 2026 SCC 689. No, 20. 2026 SCC 689.
Paragraph.
Well, this is paragraph 63. Mala, this is the judgment where ultimately, Lordship, kindly take this 2-page my note. From 2014 to 2020, Lordship may also take note, and this is also very surprising factor for me, that in 2018, why this was even not brought to the notice before the Honorable Single Judge. Kindly take, my lord, paragraph 60. There are, yes, 63 is the ultimate paragraph
63 of the judgment
of the judgment,
of the reported decision.
of the reported decision. Yes, sir, 2022. For the issue, Lordship may see paragraph 14.3 at page 720. That how it's a recording by the Honorable Supreme Court regarding Honorable Single Judge's directions, Honorable Division Bench direction, and thereafter, lastly, this Honorable Supreme Court directions. Single Judge's directions, Lordship will find paragraph 14.3.
Page number, sir?
Page number 720. It's a long judgment, 720.
Yes.
Kindly see the last paragraph. 14.3 is the quote of the single judge then concluded, thus I find that the impugned provisions of the act tend to take away the protected right conferred upon the minorities to administer such and such. Lordship may skip. Kindly come to next paragraph. The impugned provisions of the act are thus not only not in consonance with the protections granted by the constitutions, but are definitely in derogation thereof. Section 8 of the act cannot be read in isolation. Read with the subsequent provisions, there is an element of compulsion in the effect of the recommendation made by the Commission, which is really against the freedom guaranteed in Article 30 of the Constitution of India. Section 8 of the said act is hereby declared ultra vires the constitutions in view of what has been discussed before the prayer of the petitioner is molded, and section 10, 11, 12 of the act are also declared ultra vires of the constitution. This was before the Honorable Single Judge, and the date was March 12th, March 14. Next, it went before the Honorable Division Bench. That is also quoted. Lordship will see at page 721.
Classicum.
This is Placitum E6. There is a quote. This is the quote of the division bench. So far as the present enactment is concerned, we cannot deviate from the opinion of the learned single judge that such act is nothing but violation of the fundamental rights guaranteed by the constitutions in terms of Article 29 and 30 of the Constitution of India. Therefore, we decline to interfere with the opinion expressed by the learned single judge, and accordingly appeals deserves to be dismissed. Thereafter, 8. Since the Act of 2008, according to us, nothing but violation of the fundamental rights guaranteed by the constitutions to the minority institutions, it is exclusively left to the madrasas concerned, that is individuals, either to accept contention of such teachers who are already in service and permit them to continue in service, and or provide such and such who are empaneled by the commissions awaiting such appointment. With this observation, the appeals are disposed of along with the connected application. Now kindly come to 63 of the Honorable Supreme Court. And this division bench happened December 15, 9th December 15. Kindly take, my lord, paragraph 63 at page 794.
Yes.
In the premises, while allowing these appeals, we set aside the view taken by the single judge and the division bench of the High Court and dismiss writ petition number such and such and other connected matters. We also hold section 8, 10, 11, 12 of the Commission Act to be valid and constitutional. Therefore, and this happened 6th January 2020. I'm just putting a question to myself for academic purpose because now I can't say this. The Honorable Single Judge's order directing me practically was in a situation when I was not even there. But I was using the word that once something is declared ultra virus, where is the question of I to publish, I to prepare? It was not there. So this is the hard truth of the matter. I cannot question because there is a division bench judgment staring at me, upholding the Honorable Single Judge's order. But now the Honorable Supreme Court's set aside. That happened in 2020, much after. Prior to that, directions of the Honorable Single Judge. I know that I cannot say because my appeal I lost. I cannot say that. But all I am trying to say is this: whether is it possible for any selector to find an error which really affects so many persons and correct it? And Lordship, and kindly see, my lord, this is not even end of the matter, because during that time, because I was not there, individual madrasas were functioning, so they also made appointment in their own way. So they felt that whatever appointments are there, that should continue. Large number of matters went before the Honorable Supreme Court. There, in my comprehensive, Lordship may kindly see at page 191.
একটু দেখি ভাই।
পরের অর্ডারটা, এরপরে 196 এর যে অর্ডারটা আছে ওটা ডেটটা কবে দেখতো? আমাদের কম্প্রিহেন্সিভ 196 এ যেটা আছে সেটা ডেটটা। Kindly, my lord, the order starts at 190. Uh, we are informed across the bar by the learned senior counsel appearing for the petitioners that on the basis of the report which is subject matter of challenge in this petition, recruitment process has been commenced and it is at an advanced stage. The learned senior counsel appearing for the petitioner states that the employment of the petitioners continues as of today. We therefore direct that the employment of the petitioners shall not be disturbed till further orders. This was the beginning. Kindly come to 196. It starts from 195, relevant portion. Subsequently, large 195.
Yes.
There are a large number of matters listed along with the writ petition number such and such. The registry to submit an office report indicating which of these cases are the fresh matters. Wherever spare copies of such as have not been furnished, that paragraph may be skipped. Next, the interim relief granted earlier by this court shall continue to
Lord,
operate.
these situations prevailed prior to the passing of this judgment by the coordinate bench.
No, this is of order of 2024. The interim order 191, I am saying is 24. Now, when I was absent, may I just say, when I was absent because of act was declared ultra virus, in many of these vacancies for which I made an advertisements were already filled up by the individual madrasas. So all those large number of persons, one person initially went before the Honorable Supreme Court, got an interim protections. And thereafter in page 195, indicating it's a large, kindly see page 195, the first 4 words, there are a large number of matters by the it is recognized by the Honorable Supreme Court, and then interim relief earlier by this court shall continue to operate till further orders, which means
the vacancies which you
yes,
have declared have already been filled up
not,
with an
not all. It would be, I would not say much, some. Well, because ultimately
where the petitioners were protected, where the petitioners were protected by the Honorable
yes,
Supreme
yes.
Court.
All I'm trying to say that the day it was declared ultra vires, I became defunct. Somebody else started filling up, and that happened. In fact, I don't have the all detailed informations, how many would be number. And their Honorable Supreme Court also directed for a detailed
I
inquiry.
understand how it is related with this case.
Related is that first relation is there was a prolonged period when I was not there legally.
Because act was declared ultra vires.
Yes. Second was that I started the recruitment process in 2010 in respect of X number of vacancy. Some part of the X is now subject matter before the Honorable Supreme Court. All that I'm trying to say.
Any other point, Mr. Thor?
There.
এইগুলো উকিলকে দিয়ে দিন, এগুলো আমার লাগবে না, এইগুলো একটা এনভেলপে সিল করে রাখবেন, এগুলো আমরা পরে ফেরত দিয়ে দেবো, এনভেলপে সিল করে রাখবেন।
Now, my lord, I will end. I think ending should be with something which is extremely against me. That is the Honorable Division Bench, that part of the judgment in my application. Well, a page Lordship would be saying, if Lordship sees the writ petition as 65 or whatever, or Lordship was saying composite, whatever.
Whatever.
Well, there are two orders of the Honorable Division Bench.
You are referring 12-9 or
there are
4-2?
Well, I was referring 4-2.
4-2.
The last paragraph, 68. Lordship is saying the comprehensive. No, I am seeing the writ.
Then I am going there.
May I? There is a bunch of all the orders that doctor had to shuffle through the pages.
Very good, sir. It will be your generosity, but I have marked it.
Only marked
with I have marked it with the flags.
It has been given earlier.
Yes, sir.
Because once marked on a page, in my case, what happens if I mark even on a bare act? If I see something else, I am not even able to understand.
Those are only.
I think there is a visual memory that all of us we have. So, my lord, there the last paragraph.
It is order dated.
This is the order dated 4th of February 2020.
Yes, I am on that.
The impugned order, only this part, the impugned order is modified to the extent that the appellant is directed to complete the exercise strictly in terms of the directions passed in the impugned order within 6 months from date. So therefore, there was a modification.
Yes.
The modification that Honorable Single Judge's order plus 6 months. That's the modification. Then Lordship kindly come to page 74.
Yes.
74, first the paragraph which is completely against me, that is paragraph 13. That's their submission.
Yes.
That's their submission.
Yes, sir.
True. Well, 13, we are unable to accept the contention of the applicant that a plea was taken that there has been a large discrepancy in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in the written examination. I wanted more time, and this was my reason. Kindly consider that. Now 14. Such plea. So 13 equals to I wanted more time. This was my reason. 14. Such plea having taken in the writ petition. Firstly, this is factual incorrect. It was never there in the writ petition. Complete. As well as in the instant appeal. This is also factual incorrect. But was not found favor cannot be re-agitated in an application seeking extension of time. Lordship may kindly mark this. Extension of time to complete the process. These are the only two pillars I cannot tinker with. Extension of time and completion of process. I am bound to be completing it within the extended time, and I must complete the process. Your problem is your problem. Whether you want a scrutiny, whatever it happened, but that's a very usual stand of the Honorable Court in many matters for statutory authority. By saying, I don't want to enter into what is your problem.
Mr. Madhur,
Next.
kindly read the paragraph 14 once.
Yes, I'm reading. Such plea having taken in the writ petition as well as in the instant appeal.
So in the appeal, there was no ground to that effect.
I don't think it was in the application itself, because Lordship will not see in the order in the
Division means such plea having taken in the writ petition
as well as in the
instant
instant appeal. May I say what is the meaning of such? I say such means my lackadaisical attitude of seeking more and more time. That is such.
No, sir. Please state in paragraph 13, sir. We are unable to accept the contention of the plea of the applicant that a plea was taken that there has been a large discrepancy. That is the plea. That plea was taken as a ground in the appeal.
Well,
Just now you have said that
No,
in the appeal it has not been taken.
no,
It was not taken.
no, it was not there. But in fact, the other thing also not there. Lordship knows that. That's the reason, my lord, the Supreme Court every time say, do not read the judgment as a statute. My lordships are dictating in open court. It should not be seen in the light of and concreteness of every word minus the context. The context, I say that a lackadaisical person, a lazy person's coming before the honorable division bench with lame excuses. That is the context. And in that context, my lord, if I read further, such plea having taken in the writ petition as well as in the instant appeal, but was not found favor cannot be re-agitated. Now, this has to be understood. My lord, we cannot say that the honorable division bench was wrong. It has to be reconciled that before the honorable single bench also, we wanted more time by saying that we need instruction of the state. Before the honorable division bench also, we wanted more time to complete the process. That I cannot buy more time. Kindly see, my lord, 15. Since it relates to a recruitment process which is already delayed for nearly a decade, correct? But there is not an iota of sentence, Lordship, regarding I was not there for a long time. The authority must be sensitized and a sense of responsibility required to be percolated in them, that any dormant and lethargic attitude has the ramifications over the rights of the eligible candidates. Agreed. But what do I do if the court declares as ultra vires? And this is just after even possibly certified copies was yet to be got. Kindly see, then 16 is the paragraph ultimately. We do not find any sufficient reason which impedes the progress to be made. Kindly, my lord, mark progress to be made for due implementation of the order of the single bench. And I would read further in my own words, and nothing else, as modified by the division bench. So due implementations of the honorable single judge plus 6 months. Due implementations of the honorable single judge's order and nothing else. You may come today with your point of excuse of I need more time for scrutiny. I have my difficulty that somebody was left out. I don't mind. You have to complete it before. That's the order of the honorable single judge. So therefore, I have to complete it within that time. That is binding on me. But the honorable division bench did not enter into the domain of what was your problem. So my submission before your lordship would be whether error was right and whatever I did after the error, that was not a matter before the division bench for any person, for anything other than extension part. Your error, your problem, you do it, but do it by this time. That's the honorable division bench's order, in my understanding. If that is so, the honorable division bench do not say that even if you discover an error, you cannot rectify. The honorable division bench say that even if you discover the error, you don't get more time. I agree with that. Discovery of error does not fetch you more time. Now, Lordship, kindly see why we have to have the judgment that judgment cannot be read as statute. Paragraph 17 would be another example for that. In paragraph 14, well, two ways it can be read. Such plea having taken in the writ petition. Lordship is aware that there was no occasion to arise. And the only plea was that written test done, publish the result. And that's all. And intimate him. But so therefore, to reconcile, it has to be read. Such plea means lackadaisical attitude, seeking more time. You must publish it once you have held the written examination. Now, thereafter comes, my lord, paragraph 17. This 16 part, my lord, when I was reading 16, I would say that the division bench, we do not find any sufficient reason which impedes the progress to be made. Now, progress to be made is one thing, and progress to be made in a particular manner is a completely different thing. For due implementation of the order of the single bench as modified by the division bench, and the further plea of the moral code of conduct having been imposed because of the declaration. Lordship may kindly see these dates. I was seeing that it was so normal. In January 2020,
list of date একবার দেখি তো ভুল দিয়েছিল বলেন বাবু list of dates ওই জাজমেন্ট
দু পেজের একটা
ওই জাজমেন্টের ফাইলটার মধ্যে রাখা আছে
কপি আছে। Kindly come to my lord this first page, this 12/3/14. So from 12/3/14, now kindly come to second page, January 20. Kindly look at this January 20. This act gets his survival. So just next month itself. Does it make me a lazy person, a lazy body?
So I am not here
No,
to make any comment about the judgment of the
That's
division bench.
I'm aware of it.
But what I am thinking, Mr. Dhar, for the sake of argument,
Yes.
even if I accept your contention,
Yes.
that the core contention before the appellate court was in the nature of an obiter. The basic concept is that does it, if I accept your contention, Mr. Dhar, for the sake of argument,
Does it stop me to go there?
very good. But even if don't you think
Yes.
that the matter in issue,
Yes.
which is involved in Can 20 of 2024,
Yes.
is similar to the matter in issue involved in the instant need petition? So it is barred under the principle of res judicata.
No, it is not res judicata because of the reason there the matter was, do I get more time to publish the result? I am saying I have detected an error.
I understand your contention.
There is a
Your prayer was for extension of time.
give me more time.
Give me more time.
Division bench says
What were the issues for granting more time? Detection of large discrepancy in the recruitment process.
correct. So I don't get more
In
time.
paragraph number 13.
Correct. Correct.
On the basis of such contention, that applications to rejected.
Not rejected. That not rejected.
Very good. That application
3 months was given.
3 months was given,
Yes.
but the honorable court unable to comprehend your contention.
To extend further time. While honorable court did not say anything regarding
Mr. Dhar, I'm sorry, we are unable to accept the contention of the applicant that a plea
Lordship
was
is,
taken.
may I say, Lordship is reading which
Paragraph 13, sir.
13 again. Yes.
We are unable to accept the contention of the applicant that a plea was taken that there. Have you got it, sir?
Yes, absolutely.
That there has been a large discrepancy in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in the written examination.
Yes.
Very good. This is unable to accept part.
Absolutely.
Now 14.
Yes.
The explanation is coming
Yes.
from the side from the division bench.
Yes.
Such plea having been taken in the writ petition as well as in the instant appeal and was not found favor cannot be reagitated in an application seeking extension of time to complete the process.
Kindly pause here. To complete the process. I have said 1, 2, 3, 4 to complete the process.
Sir, in what perspective the commission did not comprehend your prayer? Because you have raised a plea that you have detected a large discrepancy in the scrutiny process. So in that application in Can 20, the matter in issue for granting further time
Yes.
is for detection of a large discrepancy in the scrutiny process.
Correct.
Your defense in the instant comprehensive opposition is detection of
Correct.
detection of discrepancy.
Correct.
Even then you are saying that is not hit by principle of res judicata.
No, I am saying it is not.
Even if I am telling you, I am asking one thing.
Yes.
Even if this point is not taken,
Yes.
even if this point is not taken at the time of filing that application,
Yes.
can it be not called as a constructive res judicata in the instant writ petition?
Sir, may I say that why it will not be coming within the concept of what I could have, having not, I am bound by constructive res judicata, is paragraph 16 itself. But the scope of the writ petition cannot be expanded. I was not the writ petitioner.
Of course, you may argue that it was not between the same parties.
It was not between the
It was
same.
between the same parties. That you can argue.
But there is one aspect of, kindly visualize this,
That Malakar is not here.
that part is there. I say that what impression I was trying to understand, why the Honorable Division Bench granted only 3 months after rejecting my contention. Initially 6 months, then 3 months. Reason could be that, one of the reasons could be, in the application I said that further examination. Now further examination would take a lot of time. But there is a difference between further examination of some persons who were left out, not the further examinations of already examination being taken. May I say this? If I am stopped of holding any further examination of which already happened of those candidates. So the word further usually means further comes when something already has happened. So I cannot do anything further. So once examination in 2011 happened, I cannot do it further. Does it mean I also cannot do first time for leftover on detection? That was not the subject matter. Further I cannot. Further requires, there is a prerequisite of the word further. Further presupposes already one. So I cannot hold further examination. What I have held, ultimately accepting 6 months, nothing has been, my lord, tinkered with. Nothing. And I say that whatever has been recorded against me, all are for the purpose of no further time, not for the purpose of intricacy of what I would be doing within that time as a selector under the act. Because this is my problem. Court is not supposed to take my burden. It is for me to solve it. If there was an issue addressed and decided by the court, of course, I am bound by that. And that binding nature is here only in respect of publication.
I understood.
In time.
Thank you.
I believe. Judgment বলো নামটা? Same. There is 2000. 2010. There is one judgment, 2010 6 SSC 614, that subsequent materials, my earlier view was Mahinder Singh Gill. Whatever was there in my reasoning, I cannot change that. But there is a different view here. Kindly take 2010 6 SSC 614. that 6 SCC 614,
Paragraph, sir.
paragraph 45. Six one four. Well, this is paragraph 45. No, 614. আমি 514 বলেছি।
না না স্যার আপনি 6
Yes.
45. We are of the view that the decision maker can always rely upon subsequent materials to support the decision already taken when larger public interest is involved. This court in such and such case found no irregularity in placing reliance on a subsequent report to sustain the cancellation of the examination conducted where there were serious allegations of mass copying. The principle laid down in Mahinda Singhal case is not applicable where larger public interest is involved, and in such situations, additional grounds can be looked into to examine the validity of an order. The findings recorded by the High Court that the report of CVI cannot be looked into to examine such and such cannot be sustained. This is for only purpose that 73,000 is equally a public interest, equally it's an examinations, and there Lordship has ample power to see anything that Lordship feels, because it is not a suit, not limited to just few persons.
Yes, Mr. Dhar. Thank you.
But I think
This
I-
much.
I am deeply obliged.
Yes, sir.
I appear for the parties who are directly affected by these proceedings. Because I appear for those few persons who have been selected for the employment, their name have been paneled, and they will get the employment order, but for this application.
May I know the WPA number? Item number 40. Will you please tell me the number? WPA or some. Your WPA number? 84
My lord,
845 of
2025.
বলবে তো? বলবে?
না, ওই একটা
বলো, বলো।
original রেকর্ডটা হলো। Original record. Well, there is one thing I should say, the original, that question I have given, we don't have any copy of that. What happens, no difficult, Lordship keep it, that right to information, sometimes applications and cases come.
No, it will be returned to you. It will be returned to you. ওটা একটা envelope এ ভালো করে আলাদা করে রাখো। Or you can file photocopy.
I can do that.
It's
Okay,
better.
because I saw it,
ওটা ফেরত দিও।
well, this I saw it today at
ওটা দিয়ে দাও। Only the question papers you both side you.
what happened, my lord, I wanted these documents. Now, in fact, I could see for the first time at about 10:15 because the secretary, due to medical emergency, he has gone to South India with his wife. So our deputy secretary, others, they came. I saw for the, that's why.
No, you take it back. I have seen you file the photocopies.
I can.
হ্যাঁ, photocopy।
The photocopy, should I include this resolution or should not? I should not.
Only the papers.
Only.
Just put it to resolution.
Hmm?
The press
Yeah,
resolution code.
Yes. Yes. Hmm.
This record, and we will not give it to parties. Look at that.
So, Mr. Pal, so far as WPA 845 of 2025 is concerned, that is similar to WPA 1436 of 2025 and WPA 29253 of 2024. No. Only appointment letter is there. No, so far as your writ petition WPA 845 of 2025 is concerned, that is for issuance of writ, appropriate writ directing the Madrasa authority to give appointment to the petitioners. More particular, the respondent numbers 2 to 5. Be that as it may. Similar prayer has been made in WPA 1436 and 29253 of 2024. Similar prayer. I don't know who are appearing on behalf of them. Your case is 845 of 2025? So you are at par with Mr. Pal. That I'm on. That I'm on. And who is appearing on behalf of the writ petitioners in WPA 29253 of 2024? You are also at par with Mr. Pal. Huh? I'm sorry. Yes, Mr. Yes, sir.
Meet, please.
ওই petitionটা দিন আমায়। এটা নাম।
Our case that we should get immediate employment order should be formally immediate. Now, the arguments of both sides. What is the controversy in issue here? Matter has been argued for this. What is the controversy in issue? 2 points. Whether this second written test would be held by the commission. Petitioner says because of order of division bench, it cannot be held. Secondly, petitioner says in any event, relying on the rules, that it cannot be held, written test, singular and all that. So let's take it one by one. One fact has been stated in affidavit of commission that there was a mistake on their part. And that mistake was relating to scrutiny of censure. So they discovered the mistake, and what was their obligation thereunder?
Mistake was not on scrutiny. Mistake was evaluation of papers with a wrong answer key.
Yes, that is mistake on the part of the commissioner. Evaluation done by the persons engaged by the commissioner. They made mistake, they have a commission's mistake. So the mistake is discovered. After being discovering the mistake, what options they have? I don't agree with my learned friend. That there are 3 options. Respectfully, I don't agree. Once a mistake is dictated, it is obligatory on the part of the authority to correct it. This is my first submission. Obligatory. There is no other option. Mr. Dhor himself has argued that under Rule 16, it was obligatory on their part to allow those parties to appear in the written states. So his main argument is it was obligatory, not optional. In the Rule 16, cast a statutory obligation on the Commission to allow the persons who have passed through the preliminary screening test to sit in the written examination. So why is the option? I humbly submit below, there is no option. And I'll cite judgments one after. This is my first proposition, humble proposition before Lordship for my last kind consideration. Can any authority under Article 12 say, yes, I have made a mistake, but I don't do anything about the mistake? I keep my eyes shut. Will there be reasonable conduct of an Article 12 institution? I am a humble submission, Miller. It is not so. It is not. The second point arises. The mistake does not give rise to any right whatsoever to any party. This rich petitioner's petition is based on their assumed legal right.
Sir, please spare me for 2
Sir.
minutes.
No, no, my lord.
Sir,
I most respectfully humbly submit, my lord.
sir, একটা জিনিস একটু বলি, একটা জিনিস। Hello, those question papers, they said that they won't be able to Xerox it here because it's being a confidential document.
No,
So-
then it will be kept here.
So that's either it can be Xerox from Lordships here, or they will go office, they will Xerox and give it.
No, no, no. Then I will not
No,
handle.
no.
It will be. I will record that it is taken on record, and it will be liberty will be given to you to take back
Yes.
after passing of the judgment.
Then Lordship take it.
তুমি কোথায় লিভ ডাউন এখানে ফটোকপি করে ডক্টর বলছেন এখানে কথা বলছেন
না, এখানে এনারা they are hesitating to.
Sir, I will record that the court has taken on record, and liberty will be given to the to take back those documents after pronouncement of the judgment.
Correct.
You will get it from my SEO.
or after submission of photocopy.
Correct.
After
No, if I take the original, how
There
they
is no,
will.
there is no
can be
photocopy.
taken এখানে বড় বড় লোকো কপি বলে
No, I have no problem. I have no problem, but only
expression
I am told that
আমি যাবো যাবো
this, because it contains answers also, that this is whether any normal Xerox copy shop, it can be done. They said they have never done that. That's either it should be from the court's Xeroxing, or
Do one thing, you take it back on the next day, bring the original
yes,
and
Along with
the
photocopies.
photocopies, and I shall see, and thereafter I'll hand over.
that's right
That much I can.
that
that means what is called loco copy
হ্যাঁ।
explain loco copy
তাহলে
এই উকিল বাবুদের ফেরত দিয়ে দাও, কল্যাণ বাবু, ওই কোশ্চেন পেপারস গুলো ফেরত দিয়ে দাও।
envelope করে দিবেন
হ্যাঁ, that is
must be given in a sealed envelope আপনার sealed envelope করে
No,
দেবেন
it was presented to in an unsealed condition. It was returned to the unsealed condition.
I saw it 5-6 minutes before.
Very good.
no I'm
Sorry. Yes.
I on the genesis of the matter. The petitioners who have now come to say just because of mistaken exclusion of 73,000 persons, I have a legal right to say they cannot be examined. They cannot be allowed to be examined again. What is the basis of the legal right? Each petition has to be maintained by a person having a legal right. It's a law. Asking for mandamus, everything. What is the basis of the legal right? My humble submission would be, to your lordship, they have no legal right to claim any of the prayers made in the petition. Petition copy, we haven't been served. But now we have courtesy of others, we have taken a copy. I can show the prayers. I'm giving lordship a structure of my argument. A person is saying that by mistake of the scrutineers or board, 73,000 persons were excluded from participating in written examination. Therefore, they cannot be allowed to participate in written examination. Am I right in a summary? They were excluded. Now the board in the affidavit said bona fide mistake, it was excluded. None of my learned friends on the petition said, no, it was not a bona fide mistake. It was not a mistake. They have not argued on that point. They have not disputed that there's a bona fide mistake on the part of the board, the board's agents, etc. So, lordship, in my humble submission, should proceed on the basis that there's a bona fide mistake on the part of the board in the matter of evaluation of the screening test. And by mistake, 73 persons were left out. And those 70 persons, upon discovery of mistake, has been found to be legible out of many. So, now, I respectfully submit to your lordship, most humbly submit, my lord. This petition discloses no ground of their right. That because they are once excluded by mistake, they cannot be now included for written examination. Do not dispute that a mistake. That is my second point, my lord. So mistake does not give rise to any right to anybody. Third, humbly submission, my lord. and I hope Lordship will appreciate this, the mistake is not to be perpetuated. Mistake once discovered is not to be perpetuated. And that is the ground on which review is allowed. So this may not be submission. Now, next submission will be, my lord, can you look at the conduct of these rich petitioners? Kindly look at the conduct. Yes, Mr. Everything. On taking the list of dates of the commission he has given, I'm reading from that. It also I've got prepared same thing.
লিস্ট অফ ডকুমেন্টটা দিন, লিস্ট অফ ডেট এইমাত্র যেটা দেখালাম। Yes, sir.
That yes. On 5th of August, second page was defined, 5th of August 2024, notice issued by Commission inviting 73,000 candidates for written examination to be held on 1st September. This petitioner did not object to that. When notice was issued, inviting 73,000 candidates for written examination is open. None of the writ petition came and told your lordship, don't allow this. It was taken one by one. Examination was actually held on 1st September 2024. And I believe Mr. Vishwarup Chaudhary's client had participated in that.
There is a judge in that by that name.
Then, my lord, even then, they are acquiescing in the act of the board to examine those 73,000 candidates in a written examination. Commission as a board, no commission, as a commission. Like let excuse those mistakes on my part, both calling commission, etc.
Right.
That's the mistake to be not to be perpetuated. Then my lord, written examination held is a matter of open public knowledge, notice issued, etc. They are clearly acquiescing in holding of that written examination by those signatures. Next, my lord, result was published on 12th September 2024. Here, my lord, similar this noted result, out of us 1 lakh and odd people, 3,233 were selected for personality test. Only out of them. This 333 comes from a total of 98,555. Vacancy was only for 297. Now the personality test was held on 18th September 2024. To this date. A person who has been successful in written examination will be called for personality test. In the writ petitions of all these writ petitioners, 3 or 4 in number, have they said that they were called for personality test? Have they said that we are successful written examination? And the test for this will be known to them. If they're not called for personality test, they would know they are not qualified in written examination. Therefore, my lord, it was obligatory on the part of writ petitioners who are now challenging proceedings to claim that we are successful in the written examinations. And
no, sir, their stand is completely separate.
yes, my lord.
They are saying that because of your inclusion, they have been deprived of. That is their contention.
No, no. If the condition,
And so far as the
correct.
correction or rectification of the mistake, according to you, is concerned, it is the case of the petitioner that this is not the method of correcting the mistake. They are just saying that there is a method in madness, but they say that such method has not been followed. Such method has not been followed in case of correction of the mistake. They are challenging the procedure of the commission for correcting the alleged mistake.
No, I'm grateful to my lord for clarifying to me what is the contention of the other side. And I humbly point out this contention is incorrect, both factually and on record. It's a contention they have raised, but have they said, I'm upon, have they said, and who can raise this contention? Have they said that are you successful in the examination held in 2011? Result was not declared then, but result is being published later on 12 September. And thereafter, those who have been successful written examinations are being called for personality test. So, if they are not called for personality test, that is a clear indication that they have not qualified in written examination. Held in the year 2011. I am humbly on your, my lord's kind permission on the question of their right to challenge this. Have to challenge this. If this person
Yes, sir.
had those persons who had appeared in written examination in 2011 been qualified, they might have argued, as my lord summarized their contention, that now if you allow 73,000 candidates to be brought in, we are affected. That is not the case. That contention is, but factually not correct. My lord lordship will be pleased to proceed on the basis that there is no abandonment. This is not the case in the writ petition. That we had been successful in the written examinations held in 2011. No. They do not say anywhere that we have been allowed and invited for personality test. But this is not I'm not legal right.
Sorry for the interruption, sir. How can they say their grievance is that the result was not published? How can they say, sir?
Exactly so, exactly so. Result was not published until
Their bone
not
contention is result
Correct.
was not published as per direction of
correct,
the
correct.
Honorable Single Bench and Honorable Division Bench.
Result was not published till 12th of September 2024. Therefore, they would not know whether they are successful or not.
Naturally.
That's right. But result was published 12th September 2024, and the persons who are successful were called for personality test, and it was held on 18th September onwards. So when making of the petition, the filing is filed on the final merit is written all filed on
First order 14
October
2024.
2024.
My lord,
When the first petition of this lot has been filed, the petitioner knew that he was not successful in the written examination, and this has been suppression on their part, and serious suppression. that they are not called for personality test. They have not been candidly before the court. Suppression. In fact, they have suppressed. Of a very material fact.
রিপিটিশন ফাইল হয়েছে 12/9 পর 12/9 পর সব রিপিটিশন ফাইল হয়েছে
না অনেক পরে
অনেক পর।
I've heard the argument, but can you correct me if I'm wrong? That none of the learned counsel or this petition have said that we are successful in the written examination held in 2011. And therefore have a right to say the second written examination cannot be held. This is not, I have not heard, and petition, no ground is there. Then, Milord, what comes the next round? For my laws, a lot of arguments have been made. If I want to simplify and shorten the arguments, what is the controversy involved? First of all, whether they have got legal right to challenge these things, that is a point I am indicating. Secondly, on merits also, in Reed Court, taking a pragmatic view of the matter, to quote the language of division bench, should interfere in the steps taken by commission. That's the next question. The main question. Division bench, although no ground was made out for extension of time, taking a pragmatic view of the matter, quoting the division bench, allowed extension of time in the interest of justice for the sake of so many people involved. Now, how this matter arises? This matter, it arises from a petition filed by an individual person, Mr. Malakar, and for his personal orders and benefits. It is not a public interest litigation. Now, this petition was filed in 2018 when there was no commission. This is the fact, not kindly considered. Lot of things have not been told to court. Justice Pratik Prakash Banerjee, lot of things are not told to court. That this there have been failure of scrutiny and all that. But Lordship was not told this basic fact that respondent 1 and 2, against whom I am now seeking order, they are defunct. Kindly consider this. And I made a petition against defunct persons. Commission also did not say. Court was not told that there in 2015,
18
it was an act was declared ultra vires void. And when 2018,
No, when the judgment of the learned single bench came at that time, the commission was defunct.
Yes,
a
it
lot
was defunct.
after that,
It was defunct.
after 2 years, no Lordship knows is a well-settled law. The maintainability of a proceeding should be decided on the date of its filing. If my lord wants, we can cite judgment. I don't think my lord would want it. Now, on the date it was filed, this judgment was in 2018, exact date of the petition.
exact date of the petition
I have got a copy. 2018 filed.
আচ্ছা আছে
Then,
আচ্ছা
orders are passed, being passed against the authority, which is defunct. And even if Lordship has seen the petition on which order has been passed
সোমেন মালাকার
of Suman Malika.
কম্প্রিহেন্সিভ এফিডেভিট আছে কমিশনের
ওই দেখি ভাই একটু মেন রিট পিটিশন না দেখি
In the comprehensive affidavit of the commission,
মেন রিট পিটিশন মেনটা
কম্প্রিহেন্সিভ এফিডেভিট
can you see that? Today asked a question whether division bench said something about it is stated in the petition. What actually
Page
stated now.
56, page 56,
Page 56 can be come.
comprehensive evidence.
Page 56 of the petition kindly say.
petition or comprehensive affidavit?
Comprehensive
I'm
evidence.
sorry,
এই ওইটা দাও তাহলে।
of the commission at page 56
Onward.
this petition starts.
তারিখ দেন জানুয়ারি 2018 আর এই যে 75 পেজ 2018
Yes.
75 তারিখ
That's
অ্যাপয়েন্টমেন্ট তারিখ
that affirmation of the petition is
75
page 75, January 2018. That date is given. January 2018, page 75. And matter is being taken up by this honorable court on 23rd of July 2018. And see, my lord, who are the respondents? See, my lord, East Bengal Madrasa Service, that's not 2. Deputy Secretary, Assistant Service 2. And see the orders paid for. See the orders paid for. Writ of mandamus commanding the respondents.
page 70
Page 70 of the prayer starts, my lord. Page 70. The prayer starts at page 70. Writ of mandamus, writ of and or direction in the nature of mandamus, issue commanding the respondents' authorities, each one of them, their men, agents, servants, subordinates, and were assigned to forthwith publish the result of written examination of the first level, etc., conducted on 27/3/2011. Pair A. Pair B, writ of mandamus, etc., commanding respondent, and each of them, etc., to do that, assigned to forthwith communicate to the petitioner as to whether petition has been selected with petitioner. It's a private application, a personal private application, not a public petition. Petitioner who has been selected, not let you know. And who let you know, man? Totally private. Now, other prayers at the writ of,
So very good, sir. So how does it make the difference?
my lord,
How does it make the difference?
difference whether proceedings are void or not. Proceedings are
That will be adjudicated by a coordinate bench.
My lord, therefore, my lord being asked to adjudicate on the order passed for extension of time by the division bench. That is my humble smile. I humbly agree, Lordship. This is not material. Extension of time, etc., are not material. Lordship is being asked to form a view on the basis of order made on extension application, which are interlocutory orders. And court is extending a time, I'll come and tell you some actual fact, of an order passed by the court against defunct, non-existing defunct authorities. Therefore, strictly follow, all along order, strictly follow the order of single bench. And this is not the end of my point. This is indicating the procedure, how much reliance can be placed on these proceedings for initiated by Mr. Malakar for his private benefit, and how far it can be generalized to affect non-parties. That's why my question is coming to. A private petition is made for personal interest, personal order. How can it be generalized, any order, to affect non-parties? Any order passed therein? including orders for exchange, etc.? This is the question I'm coming to, Milord. That is my purpose of submission. Mr. Dhar has argued, like the several judgments, how to read them, how to omit a dictate, etc. I'm not going to. And he said, what can be legally be deduced from an order of court? I will humbly point out, in an order which is illegal, which would not be valid according to law, which will be contrary to law, cannot be deduced from an order of High Court. Let us at least agree that our honorable court will not pass any order affecting third parties without giving them notice, without hearing them in violation of natural justice. So argument, Milord, that the order of court passed in these proceedings arising out of Petition number 1722 debars the commission from allowing non-parties to appear in the written examination and get themselves appointed.
That is the core issue.
That's the core issue. That's the core issue. And not, I humbly submit with respect to my learned friends, that let us not assume that our High Court will pass such atrocious order in a proceeding to which the parties are not made party, and proceeding which is private proceedings. High Court has passed an order affecting 73,000 persons without hearing them and violation of natural justice. Let us not assume, as a criminal netman, our High Court is not of that standard.
Sir, your right accrues. Your right accrues while you have succeeded in the written examination. Your right accrues while you succeeded in the viva voce examination. But the writ petitioners who are opposing the act of the commission, raising the action of the commission in holding the second phase of written examination.
That's when.
So when they question the right and power of the commission,
Yes, my lord.
in holding the second examination,
Yeah.
your right at that material time was not going to be affected, and or it is your right is not going to be touched at that very juncture.
This contention made by your lordship factually incorrect contention. So, your lordship, they are now saying that some actions are wrong. I mean, correct me if I'm wrong. But that step, that view was not being taken when the acts are being committed. When the acts are, what are the illegal act according to them? Inviting notice, inviting those 73,000 persons to sit in written examination. When that act is committed and person there to written examination are being held, have been held to knowledge of everybody, there are no objection. It is thereafter, when the results were published, and
So
my
subject
clients,
to correction, so far the filing of writ petition is concerned, there is no period of limitation. Obviously, the writ court deals with the subject of delays and laches while taking a writ petition.
but I have not
So-
good. I will not argue.
will it be, is it
And-
your argument, sir? Is it your argument that there was inordinate delay and lapses on the part of the writ petitioners? Will it be your argument, sir?
I will be acquiescence. Acquiescence. Knowing the fact, you have acquiesced in allowing the written exam to be held, to personally test to be held, and result to be published. And after finding
That you have argued, sir.
that is point. That please don't think, Milord. I don't know, but I may be anything, but I will not
No, sir.
I will
It is.
argue
It is.
before the
I'm.
writ court.
Don't think, sir. I'm asking some questions. It's don't think. Don't take it otherwise. It is for my learning or in order to come to a logical finding.
Well, writ
Don't take it
petition-
otherwise, sir.
Writ petition is barred by limitation. That point, Milord, I don't think anybody in the High Court level will argue that. So please don't bother about that. Milord, delay is a bar. That is discretionary bar, not absolute bar.
Absolutely, sir.
But Milord, when a party has allowed some act to be perpetrated and completed, then after seeing that his name is not there, he is not successful, if he challenges, then what view court will take? What view court? That is the point. It is discretionary order, writ petition, all discretion of the court. This is the point.
Sir, I'm sorry once again.
No, Milord.
Kindly come to the second page of the second page of the
List of
list of dates.
yes, Milord.
Sir, last three rows.
Which date?
1/9/2024.
August.
Written examination held.
5th
12/9/2024. Written test published.
1/9,
From-
12/9.
12/9/24. Yes.
Have you
Milord.
got it, sir?
Yes.
1/9/2024.
Hmm.
Written examination held.
Yes.
12/9/2024. Written test published. Result published.
Yes, Milord.
18/9. 5 of stars.
Personally test started.
13
So fast track.
Yes. Yes.
So fast track.
Yes, Milord.
pursuant to the order of the Honorable Petition Bench.
It was to a knowledge of everybody. That can be added to the knowledge of all the petitioners.
So, for the sake of argument, if I accept your contention that there was an acquiescence on the part of the writ petitioners, it was an acquiescence for only 6 days, whereas the recruitment process was initiated in the year 2010 by publication of an advertisement in the newspaper.
Yes.
Just see the, sir,
Yes.
there's a read code, sir.
Hmm.
Issuance of read, sir, to my humble understanding, it is a discretionary,
Yes.
highly prerogative one.
Yes.
So the conduct is to be considered, sir.
Yes. Yes.
Recruitment process of 2010,
I'm blessed.
result published on
Hmm.
examination held on 1st September, for 12th September result published, 18th September onwards
Personally test held
started.
and not can
Just see the
Hmm.
fast movement of the
also can add a date here. 4th October, final merit list published. 4th October 2024, final merit list published, 295 eligible. But I am
they are, sir, we see it, we have to see it, we see it from naturally at an upper level. But the judge must visualize from the ground level, sir.
Hmm.
Who are the litigants before us? How it is difficult for them to approach the High Court. How it is difficult to approach the lawyers. So these things are also to be considered.
yes, absolutely.
And they are applying for which post?
Yes,
Had it been a post of director or a managing director or a CEO of a
Group D.
authority, I corner. It's a group D.
Can you bear this in mind? Group D. How much written test is important? Anyway, as my lord said, if I may borrow from my lord's expression, that litigation, lawyer, etc. But my lord, would I not expect at least a letter written by any of these parties?
Sir,
be
for
signed?
approaching, I'm sorry for the interruption. For approaching court, I'm telling you, sir, you are much experienced than me, and
No, no,
you are
no, please.
you are much experienced than in much older than age.
Older
So
in age,
I
accept.
respect
Older in age, I
I
accept.
respect your age, prudence, and experience, sir. But I have little bit experience,
Hmm.
sir. Only monetary ability is not sufficient. Mental strength is also
Yes,
very much required to
yes,
approach a
yes.
court.
Yes. Now, my lord, may
So
I?
people are very hesitant to whether to approach or not. We'll go to the lawyer.
Right, right.
Even the village,
Yes,
in
yes.
village, sir, the people feel comfortable in approaching the law clerk of town that way.
Yes.
I'm telling you the ground.
Yes. Now, may I only humbly said, my lord, that's to consider. I am complaining about non-approaching the commission. Why didn't they write a single letter to the commission, approaching the commission that what you are doing, don't do it. Not on court. Acquiescence in a proceedings is different thing. It does not require anything else. They acquiescing a proceeding initiated not by the court. They are proceeding initiated by commission. So their objection should be to the commission. High Court at the stage far above. Then later on, my lord said, commission approach, commission was told it is wrong, it is we are doing totally incorrect, don't do it. In spite of that, commission continues, then people think of coming to the court. I am kindly will I remind that approaching the authority who has started the proceedings. Well, that is one point, matter of discussion. I don't think this point will clinch the issue and dismiss. But one of the factors to be considered by the court, because they are rich court. Let us see other factors, my lord. Other factors. Now, other factor is the division bench supposed to have prohibited holding a written examination, second written examination. The stand of the board is very clearly on a comprehensive affidavit at page 27. Paragraph S starts at page 26.
Page number, sir?
Page number starts at 26 at 27. Subparagraph S, paragraph 26. That in terms of paragraph number 17 of the judgment and order dated of the Honorable Division Bench, passed in connection with the MAT number, along with CAN number, with etc., it is stated the Honorable Division Bench has never restrained the recruiting authority, being the respondent commission, hearing from conducting the written examination of the left out candidate as stated here. That is a stand. Commission cannot take any other stand now. That is a stand taken. Now, is this stand, as a commission stand, I am supporting this stand.
Naturally.
It's a,
Yes, sir.
now, what is the order? May I point out to your lordship this that Daniel can miss it? When the appeal was being heard, order of Justice Pratika Prakash Banerjee, that was passed when there is no commission defunct. But when the appeal was being heard, final order, this act has been resurrected.
When the appeal was heard?
This act has been held to be valid by Supreme Court.
I see.
This maybe other missed the point. I shall point out to your lordship. This division bench act was validated on 6 January 2020, and the division bench And division bench order in appeal is dated 4th February 2020.
Sir, what is the date, sir?
In the list of dates, 4th February 2020. Division bench order in appeal.
Very good, sir.
Then the commission could appear. Commission, how their perform is for them to describe. Nobody told the division bench when the order was passed, there's no commission at all. Anyway, let us see what division bench holds. Before division bench, the commission now says the order is valid. Yes, order is valid. We not dispute. Only extend the time. Only time given is too short. Kindly make it longer time. That is nothing. The division bench has no opportunity and clearly said so. I am not delving into details of the matter because both sides have consented to the time being extended. Let's see that paragraph. I want to see that. Must remember that.
Grounds of appeal has been not been praised. Only prayer was for extension of time.
And the writ petition also consented to the extension of time.
Very good, sir. Absolutely.
Therefore, matter was merit of that order was not considered, not required to be considered.
No, merit of the order of the learned single bench was not required to be considered.
Not just right. Don't
Was
require
not
to be
required
considered.
to be considered since on behalf of the commission the grounds of appeal was not preferred. On
Yes,
the
sir.
contrary, they prefer extension of time which the writ petitioner has.
Exactly. Summary better. That's what I myself pointed out.
Yes.
Although the order was totally void.
Sir, let us come back on another day.
Tomorrow may I continue or?
Yes, sir, you can. আমরা কি কোনো ডেট রেখেছি? বললেন আমাদের এই অর্ডারটা দিতে।
Tomorrow,
তাহলে উনি কন্টিনিউ করবেন।
tomorrow what time will convenient?
এই ফাইলটা দাও না।
At 2 p.m. also, and whatever time will. I'll like to conclude tomorrow.
ওটা চলবে
আমরা কি
I'd
অর্ডার
like to
করেছি?
conclude tomorrow.
ওখানে আসতে কষ্ট।
June 23 and it was
Acha.
an order was passed that it will be listed on June 23 and 25 and June 26.
My lord,
No, they may have
that is
difficulty
Mr.
to.
Because Partha Chalchu, because he will not be there tomorrow. Because him, or my lord, original observation was 2 successive dates.
Of course.
Then it was pointed out that Mr. Bhattacharya will not be available. Then my lord made it instead of Tuesday, make it Thursday. Since Tuesday, I shall be arguing if my lord so is convenient for lordship.
No, it's
Mr.
absolutely
Bhattacharya
convenient.
need not be there.
Have you got any objection? If I fix it to tomorrow? No, 2 p.m. 10:30.
Because of that two successive date,
Then it will be listed on June 26. Then because the motion may, sir, I cannot.
Subject to my lord's convenience. Subject to my lord's convenience.
Very good, sir.
Every council wants to finish the It's my argument, Miller.
Absolutely,
The
sir.
council wants.
It would be convenient for all.
Yes.
Anyway, what can be done?
Chain of thought is lost otherwise.
Yes, yes.
আপনার পেন্সিল নাকি ঢুকিয়ে দেবো আপনার
So
So,
actually,
Mr. Mitra,
October.
before I'm sorry,
I'm
before rising, sir, once again, I'm rather in court. Court is tendering apology for putting maybe some irrelevant question. It may embarrass you, but it is for only. I'm telling you, it is only for the purpose of
and may I,
going to the merits of the case.
may I only add, Miller, I don't take it as interruption. I welcome is an interaction, and I always welcome interaction with the bench. The Manalot is candid enough to express your views, giving an opportunity to the party
So that you
to
can
deal with
reply.
that.
So that you can reply, sir. Very good, sir.
Yeah, but not
So let us
interrupt. Please express Manalot's view as often as you like, and point out when my argument is not acceptable. But then we can.
No, sometimes what happens, sir, if the judge puts some question, the lawyer may miss the link of argument. That may cause, but it is sometimes it becomes necessary. What can be done?
Lawyer with some continuity of thought.
Very good, sir.
will-